Can an MBBS doctor do surgery? Honorable Punjab and Haryana High Court, which had held that as the practitioner in question has not a special study on the subject and as such she can't be considered an expert and her evidence is not admissible అని can an MBBS doctor do surgery అనే క్వశ్చన్ వేసుకున్నారు. The following is the excerpt of press note released by the AP Medical Council. This press meet is convened to clarify the stand of AP Medical Council on the controversial issue of can an MBBS doctor do surgeries. MBBS degree itself says Bachelor of Surgery and Bachelor of Medicine. In the MBBS course, a student will have 6 months surgical ward posting and later specialty surgical postings. In housemanship, he or she is posted in surgical ward for 2 months and 1 month in surgical specialties. As per the curriculum, they are trained in minor surgical procedures, obstetrics procedures. The National Consumer Forum found fault with the doctor because he falsely claimed that he is an MS surgeon. In reality, he was not an MS and he did major surgical procedures causing damage to the patient. There is no controversy that an MBBS doctor should not do major surgical procedures as pointed out by National Consumer Forum. That means an MBBS doctor can do surgeries. Training in an MBBS doctor can do all surgeries where he or she got adequate training to do such surgeries. Entitledness of MBBS doctor to conduct surgeries vis-a-vis rule position as laid down in IMC Act 1956 and IMC Regulations 2002 as amended in 2004 and 2009. There is no provision in IMC Act 1956 which prohibits MBBS doctors to do surgeries. Surgery is a main subject during the 4.5 years course of MBBS. During clinical postings, they treat surgical patients under the supervision of the experts. During the 12-month period of compulsory rotating internship, the internees are posted at least 2 months in surgical departments and they have to treat surgical patients during that period. The entitledness of registered medical practitioners is specified in section 27 of IMC Act 1956 as follows. Subject to the conditions or regulations laid down in this act, every person whose name is for the time being born on the Indian Medical Register shall be entitled according to his qualifications to practice as a medical practitioner in any part of India. The Honorable Supreme Court's judgment in Poonam Verma versus Ashwini Patel case has taken into consideration of the decision of Privy Council in the year 1937, reported as 1937 MLJ 197. In this case, the Honorable Supreme Court made an attempt to discuss the application of the doctrine sic uteri leo iti alienum non laedas. In the practice of medicine, this means so use your own that you harm others. This refers to the practice of medicine by unqualified persons. In all cases where allegations were made against doctors for their negligence, the Honorable High Courts or National Commission or Supreme Court expressed the view that a doctor is not negligent when he has observed standard protocols during the course of his practice. In all cases, the constitutional courts or the state commissions or national commission have taken into consideration of the provisions of IMC Act 1956, IMC Regulations 2002, together with Consumer Protection Act 1986, having due regard to the facts and circumstances of the case. The principle laid down by the Honorable Supreme Court in Baldevraj versus Urmila Kumari. The practitioner may not have specialized in the branch of medical treatment of women's disease, but her knowledge of midwifery as an obstetrician proved to be of the higher order in case of itself. In this case, Honorable Supreme Court reversed the findings of Honorable Punjab and High Court, Haryana Court, which had held that as the practitioner in question has not a special study on the subject, and as such she can't be considered as an expert and her evidence is not admissible.